Good afternoon, everyone, and welcome to the AMPC webinar today on bullying and harassment and the law. So this is the first of a four-part series around bullying and harassment, which will be run over the next sort of 6 or so weeks. So we're very lucky today to have Andrew Douglas from FCW Lawyers to join us. For those that have watched a few of our previous webinars, Andrew's was very well received last time and gave us a lot of really good insights. Also joining us is Simon Booth from Aegis Insurance, who has been tasked with the current AMPC project, which this is one of the initiatives out of, in looking at how to make the meat industry a safer place. So we thank them both for coming online today. For those people that are new, we really encourage questions. So if you've got any questions, please feel free in the toolbar to type your questions, and then at the appropriate spot we will send those questions over to Andrew for him to be able to give a bit more information and a deeper dive into and hopefully answer everyone's questions. For those that registered earlier, I have sent you out a workbook. That workbook will be used during today's presentation, but it's also a good reference for future any training that you're doing on plants or any sort of references that you want to go back to. And I've also got the answers for those workbooks that will be sent out after the webinar, so we'll make sure you get those. For those that have registered in the last hour or so, during the presentation, I'll try and email those workbooks out to you so that you've got a copy of them in front of you. So, Andrew, I'd like to hand over to you to start the presentation. Thank you very much.
Thanks very much, Amanda. All right, let's just jump into it, and feel free to ask questions as we go. And Amanda may butt in what I'm saying and say, Andrew, I've been asked this question, and we'll try and answer them as we go. I don't want you to save them up at the end because you'll probably forget the things you really need to know. Simon and I have built the workbook, so it helps you today, but more importantly, you can take it away and use it as a tool for when you're managing in your own workplace. It's very simple structure. It talks about what is the law, so that there's absolute clarity around what the law is, but it also tells you how to apply the law, and that's really what we're going to do today. There are 5 key definitions that we're going to deal with today, which is bullying, discrimination, harassment, victimisation, vilification, and adverse action. But what we're really going to focus on, which are the most common problems that we have, are bullying. We're going to look at the meanings of discrimination, so you understand there are different types of discrimination, and often we don't realise that the behaviour that we're doing is a form of discrimination. And then we're particularly going to look at treating people differently as a result of physical or mental disability, because overwhelmingly the people that we deal with and who become disputatious are people who feel they've been treated badly and they complain they've been bullied. Often that's raised at times when you're trying to manage their performance. They say, oh, look, you're treating me really badly, and as a result of that, this needs to stop because I'm feeling bullied. Or they default into a mental health issue and say, look, I'm too stressed to actually participate in this performance management. Can I just be really clear now that for a person to be at work, they must be able to be managed. So it doesn't matter whether they had their leg chopped off and they're hopping, or whether they're suffering from severe depression. If as a result of their injury or illness, they are unable to be managed, they're unable to be at work, okay? They can't be managed, they are not fit for work. So it's very important that we're clear about it. When we talk about what are the inherent requirements of someone's job, one of the inherent requirements is that they can be managed. All right, let's just talk a little bit about these 5 elements, and then I'll go through what the definitions. But what I want you to understand is that each one of these elements is misconduct. In fact, it's serious misconduct. So when we look at what someone does when they bully, which is repeated actions, which have the objective effect, in other words, which would be reasonable to say it would hurt, humiliate, or intimidate somebody, and it affects their safety at work, that is bullying, okay? Now, we don't often see bullying because it's pretty bad misbehaviour. So if I can say to you in a very simple way, when we look at misconduct, we go from down the very bottom to people being a little bit rude, a bit dismissive, And then you go along that line of misconduct and you get to serious misconduct. And serious misconduct is defined under the Fair Work Act, and that's found in Regulation 107. And that says that any serious or imminent risk to someone's health, any fundamental action which attacks the reputation, financial viability of the organisation, any failure to comply with a lawful and reasonable direction, they're all things which are deemed to be serious misconduct and they warrant summary dismissal. So if we find someone actually has bullied, then it is serious misconduct, okay, because it has affected someone's health in their workplace. So the level of conduct is so profound that it's damaged someone's health. Now, on any basis at all, that person's employment should be terminated. So what I want you to understand when we talk about these things, there is a lot of lesser behaviour which is also misconduct, and I want you to stop that. I don't want you to get to a stage where we've had someone who's discriminated. I don't want us to get to a stage where we've had someone who's bullied, because by that stage, people have been injured, okay? The other thing is that any one of these behaviours breaches the contract of employment, because in a contract of employment, they are required as a matter of the common law to do everything that is in the best interest of the business, to exercise due diligence and care in carrying out their duty, and to comply with lawful and reasonable directions. And your policies and procedures all prohibit this conduct, okay? So good things to know that when someone does this, you are going to discipline them, and it is probably going to move towards termination of employment. Okay, let's just talk about what the definitions are now. Now, bullying I've already defined for you, so that's easy. Let's just do it again. It is repetitive. So if I turn around, it's my dog over there on the couch, and I thump the dog. I haven't bullied the dog, I've assaulted it. Okay, very serious, the dog won't like it. But that's an assault. But if I do things like constantly exclude it from being a member of the household, if I give it jobs which are outside of its skill to do, or pile work on it, I do all those sort of things, which is different the way I treat others. And I do that repeatedly. It humiliates, intimidates them, and has an effect on their health and safety at work. We're getting some stuff moving here, Simon. It's exciting. That's bullying. Now, discrimination means to treat someone less favourably as a result of a protected attribute. And you'll find in your workbook, what I've done is I've listed every single protected attribute in every single jurisdiction in Australia. And there is some overlap because there's a federal jurisdiction as well. But an attribute is something which is defined by law to be protected. And it could be someone's gender, whether they're male or female. So if I treat someone adversely and say, look, I'm sorry, you can't have that job because you're a woman and it's a hard job, that's very clearly discrimination, because it creates a detriment to that person, excludes them from the job. When we talk about harassment, we're talking about a very different concept. So it means that in relation to a protected attribute, there is behaviour that is being directed that is unwelcome. So if we use the woman part again as the protected attribute, so gender, and there is conduct which is seen to sexualise them and treat them in a way which is inappropriate, that conduct of doing that is the harassment. It is unwelcome. It has not been consented to. It is contrary to the obligations under discrimination law because it goes to a protected attribute. That is called sexual harassment. Okay, so harassment means, and usually is repeated, and unwelcome acts or remarks in respect of a protected attribute of discrimination that has the effect of offending, intimidating, or humiliating a person. I want you to understand that when you look at the word harass, the history, so lawyers look deeply into words. I know lawyers aren't all that loved, but one of the things we do as a matter of course is to define exactly what a word. Now, when you harass someone and you look at what the dictionary means, it's actually to inflict pain. So discrimination is bad because that describes the way you think about something. I think women shouldn't have this job. But harassment is a much more deliberate action. Harassment is something that is directed at somebody. And that's why harassment is so much more serious, okay? And when we see harassment, I want you to understand the courts view harassment as incredibly serious. The last 4 or 5 major sexual harassment cases have led to findings of over $100,000 in penalties. So they're called general damages, which if anyone's had a common law action, There are 5 heads of damage that a person can claim against an employer. There is general damages, which is the loss of amenity, the loss of feeling safe in yourself, the loss of your ability to do so. Then there is past and future economic loss, and past and future medical loss. Now, what loss means is, what I haven't been able to come to work, therefore I've lost. At the time of judgment, there is an estimate done of what the future loss will be going forward. But when the general damages is $100,000, the business is in a lot of strife, isn't it? Because if the person's unable to work again, the total claim could be worth $1.5 million. And what I want you to understand about discrimination and harassment is, once the employer, that's you, trains people in it and they are competent, you must be satisfied they're competent in it, you can sever vicarious liability. That means the employer will not be liable if they can demonstrate they've done the right thing. The person who'll be liable is the person who's discriminating and harassing. So when you take my workbook and you use it for training, and I invite you to do that, make it very clear to everybody and test people as you go to be satisfied that they are competent, and say to them at the end, there's a whole lot of reasons for doing this. One is, we don't want you to bully, discriminate, or harass somebody, but we want you to be very clear that if you do now, you're on your own and we won't be backing you, and it'll be your house that's on the line. Okay, so remember, with bullying, discrimination, and harassment, it doesn't have to be intentional. Okay, you don't have to intend to do it, you just have to do it. Now, victimization is incredibly expensive. It's much worse than harassment, because what it is when a person has raised a complaint or is seeking to litigate, that you treat them badly as a result of that. So the person, let's use this continuing story of the woman who feels she's been sexually harassed. She goes and sees HR, and the person who she's complaining about hears that, and he and his friends deliberately ostracize or exclude her when she comes back and stare angrily at her. That's victimization, treating her adversely as a result of making a complaint. Now, vilification is a different concept. Vilification is inciting hatred, basically. For those of you who are Herald Sun readers, and there may be some of you, Andrew Bolt was charged with a vilification, because it's a quasi-crime, in relation to some pretty horrendous stuff that he said about Aboriginal people. He's constantly complained about the finding against him. There's only 2 or 3 people who have ever been charged with vilification. But what that means is somebody who goes out of their way to incite hatred, contempt, revulsion, or ridicule against a person with a protected attribute. And vilification is really quite limited. It's actually limited mainly to someone's race, although there are some around religion and sexuality in some states. All right, vilification, very, very rare. Okay, very, very few people deliberately and intentionally go out to hurt people, and you don't normally employ those people. The last one is adverse action. So when we look at what are the nature of claims that an employee is likely to bring against this organisation, they can bring an unfair dismissal claim, and that's directly against the employer. They can make a workers' compensation claim. That's directly against the employer. If that workers' compensation claim matures into what's called a common law damages claim, they will name the person who is the wrongdoer in it, as well as the employer, but the insurer will meet the entire cost of it. So when we talk about unfair dismissal and workers' compensation, and Simon and Jay and others will talk more about workers' compensation, I want you to understand that the complaint doesn't really affect the wrongdoer. But when we talk about discrimination, harassment, victimization, and vilification, adverse action, you can bring the claim directly against the person and the organisation. The organisation can sever its own liability by showing it has trained people, they are competent in it, and has enforced its rules. And this person did something with the knowledge that what they did was wrong, and the organisation couldn't have stopped them doing it. And at that stage, the organisation is not liable. Okay, the organisation is not liable, it is the person who did it. There's a fundamental and really important concept. And the difficulty when we look at meat processing is, as an industry, is there is a more men than women. There is a very collegial or a sort of group or team feeling where people work together. And a lot of conduct is actually condoned. A lot of behaviour, and I've been working in the meat industry now as a lawyer to it for nearly 30 years. When I come and sit down and when I take witness statements from people, everybody uses rough language. Can I say rough language is not a basis for terminating someone, okay? Because the courts understand that places like meat processing works do have colourful language. But if that language changes to be abusive or hurtful, then that really is a big problem. And the in-jokes and the mate culture that exists in meatworks occasionally means that that colourful nature of what it is in working in a meatworks crosses a line and becomes unlawful behaviour. And the best way to test when it's unlawful is if any person looking at that would have a view that it would hurt somebody, then you know you're in strife. Okay, so adverse action just means treating someone adversely because they have what's called a workplace right. It could be someone raises a complaint that they're not paid correctly. Well, being paid correctly is a workplace right, and raising a complaint about a breach of workplace right is a workplace right as well. It could be like our early example where a person says, I don't like the way you're performance managing me. I think that what you're actually doing is you're bullying me. It's not really performance management. Now, they've raised a complaint. Now, what is a complaint? Let's just stop and have a think about that. When you look at your policies and procedures, some won't be right. Some will say things like, you're only obliged to act upon a written complaint or a formal complaint. But the case law is really clear where any person raises a breach of the law in any way or a breach of your code of conduct or values, it is a complaint. So for the tire kicker person who comes to you and says, I want you to know Ren's pretty unhappy, you know, the way that John, the supervisor, is acting, he's pretty rude to people on a regular basis. I don't want you to do anything about it. I'm just letting you know. Well, too late, because we have a common law duty and a duty under safety law to actually act the moment we become aware of a complaint. So when people say that to me in law firms, and I've been managing partner in 3 law firms and I've been head of workplace in the other 2, when they raise it with me, I go, no, just stop here, I just need to write this down. They go, well, what are you writing it down for? And I go, well, because you've raised an issue and it's a concern to me. And they go, well, I don't want you to act on it. And say, well, but I am going to act upon it because you've raised a breach of the law and I have no choice but to act upon it. So again, have a look at your policies and procedures and make sure they don't exclude your common law and safety law entitlement to actually proceed once you have a complaint. All right. Now, there are 2 sorts of people who raise those. There are tire kickers, and you can be more forthright with tire kickers. And there are very vulnerable people who come to you for the first time. And then you can say to them, look, you don't have to make this a complaint. You can tell me what your concerns are and I can act upon it independently and I won't name you as the complaint. So I can do that. Isn't that good? I don't have to have a complainant, but just make sure your policies and procedures allow you to have this step out clause which says, I have the capacity to act upon it, okay? So adverse action, very straightforward. What I want you to know, the real trick with adverse action, which is in the Fair Work Act, is that it has unlimited compensation element to it. So there is no ceiling on it, like unfair dismissal is 26 weeks. You can go against individuals and you can get other orders like injunctions stopping people doing things. It is also incredibly cheap for an employee to run and incredibly expensive for an employer to defend. So be wary of it because it is a very familiar path at the moment for people to go down. Now, the other part with discrimination, since a case called Oracle and Richardson, is that the clever plaintiff law firms, when there is some form of discrimination, are definitely running it under the federal jurisdiction because it is a cost jurisdiction. For bullying, for discrimination, harassment, in all state-based, there is no cost. In other words, if you bring a claim, you can't get your costs. But under the federal jurisdiction, you can, okay? So, and Richardson Oracle there was a very large offer made by Oracle to Mr. Richardson. She didn't accept it, and she ended up having a huge offset on the cost she had to pay them back for not accepting the original claim. So a lot of strategy around that. But Simon, let's just move on to our next part. So what I want you to understand is we've talked about what is misconduct. We've said these 5 things are very serious misconduct, okay? For those of you who joined with me last time, I'm not going to spend a lot of time on this, but this is my little way of you defining what is good behaviour, because you actually can't talk about bad behaviour until you know what good looks like. 3 C's for me are clarity. When a person's asked to do something, or when there is a process or a policy that says you're not to do something, is it clear? Can people really understand that? Are they capable of doing it? Now that means, are they physically capable? Are they psychologically capable? Do they have enough English language to understand the English policy and the English training? You've got to understand, are they capable? Where we find most difficult people is not in their lack of clarity about what their role is, or their lack of capability, because they were hired to do the work and they were capable of doing it at the time. Where we normally find the biggest problem is in the 3rd C, which is commitment. They're not committed to the organisation. They're not committed to doing the good thing. So I want you to use that as we go through and we look at any bad behaviour that comes up, and ask yourself, so talk to me about think about the 3 C's. This person said, look, I couldn't do the job because the line is sort of going too fast and you haven't really given me the tools. Well, where am I going to find out, could the person do that? Well, the first thing is they'd say, well, why are you here? And I'd go and have a look at the business plan, which tells me the line speed's fine. I know our purpose is to make sure that we slaughter and cut sufficient meat for the export market. I know that's what we do, and it has to be of a high quality and good hygiene level. So I know that people working on this line have to be able to do that job, which is set out in their job description, to achieve these financial outcomes to deliver our purpose, which is an export-based meat processing, for instance. So I know what's there. So when someone's telling me they can't do something, I'm looking and going, but we've run above this line speed without difficulty ever before. So it's you, something about you. So the next question is, are they not capable of doing it? Do they not have the skills? Are they not strong enough? What is it that's about their capability that prevents them doing it? Well, no, they are capable, because I've gone back and looked over time, and they've been working for 3.5 years. And during that time, the line speed's been up to 20% faster. And we've had a bad mixture of cattle. Some are dirty, different sizes. We've had a whole lot of stuff. And there's actually no reason you can't do what you're meant to on this line speed. So the question then is, well, must be commitment, mustn't it? You just mustn't want to do it. You don't want to work that hard. Now remember, under the common law, all employees have an obligation to act diligently, to work hard with care and skill. That's why when we talked about this last time, I said to you, learn what the common law obligations are. You'll see it's under the heading what down the bottom. What defines good behaviour within the organisation? So we know how you're meant to behave. That's in accordance with the values and the code of conduct. But what is it that you must do? Well, you must comply with the policies and procedures. They're lawful and reasonable directions. You must comply with your common law obligations. Always comply with lawful and reasonable directions. Act in the best interest of the business. Act in a diligent, capable and skilled method. Okay, so we know those things, all right? And I'm teaching the workplace law today. So if we look at a person and how they behave, we go, okay, why are you doing the work? Okay, we know what we're doing as a business. Our job is to do this to achieve this outcome. We know what the business plan requires us to deliver on that day, and it's one which we've met before. There's nothing exceptional about it. And we know what your job is. Now, if your job descriptions aren't up to date, you've got a real problem, haven't you? Because you actually can't determine what good work looks like if you don't have up-to-date job descriptions. We then say, okay, so you're doing the job in accordance with what the business wants, and the way you behave is in accordance with our values. So any of the 5 things I've told you we're talking about, bullying, discrimination, arrest, they clearly breach your values and code of conduct. It's very clear, okay? And what happens when you do that? Well, what happens is we go to a policy and procedure, and a policy and procedure has 4 key elements. It says, what is the intention of the policy? It tells you what you're not allowed to do. It tells you under what law you're not allowed to do it. And it says, if you do it, you could lose your job. That's what a policy is, okay? Now there's a case directly on that says that's what a policy is. Anything that doesn't do that, I'm afraid is not a policy and procedure. So you know what the 3 C's are? This is what good behaviour looks like. Acting in accordance with the business needs, in accordance with your job description, following the values and code of conduct as to how you behave, and in accordance with the law, which is what we're talking about today. that's good behaviour. Anybody who doesn't do that is committing misconduct. Can that be clear? It's black and white. This is what good looks like. Any deviation from that is not good. Now remember, the meat processing industry is terrible at letting people drift away from being good, partly because of relationships they have, partly because they've been there for a long period of time, partly because the supervisors don't like telling people to pick up their game just a little bit. They wait for things to go really wrong, but we know when things go really wrong, it's just too late. We need our supervisors driving good behaviour every day to sever vicarious liability so the organisation is not liable, and to make those people understand that if they do misbehave, they lose their homes. So this is what good behaviour and defining misconduct is about. Once we define good, we know what is bad. We've used my why, how, what pyramid to be very clear about that, and we know the 3 C's are our method of analysing whether a person's acting badly or not. And that all falls back to our supervisors. Are they doing their job well? Do they know what the policies and procedures are that relate to them? Are they aware of what the obligations of the employee are under their job description and what the expectation of the business? Do they know what good behaviour looks like through the values and through the code of conduct? Well, they've got it, don't they? Because that's the key part. So what comes out of that is, when we talk about this type of stuff, we've got to train people. Now, under a safety, it's very straightforward, okay? And remember, we're really talking about safety because safety sits beneath all of this. Safety law says you must do everything that is reasonably practical to provide a safe place of work and have a safe system of work. Reasonably practical means that you as an employer, you as a manager, you as a supervisor must identify any hazard. Now that can be a hazard that's physical, it can be plant-based, or it can be psychosocial. It can be the way someone is being treated. Once you identify there is a hazard, and you don't have a choice, it's reasonable, it's what's required of you, not what you actually do, it's what's required of you. If a reasonable person, if a good person could identify that as a hazard, you have to identify it. And the moment you identify a hazard, you've got to determine the level of risk. All of you know this back to front. Level of risk, frequency and risk. Okay, risk of injury, seriousness of injury. Well, we know if you treat someone badly, you bully them or you discriminate against them, it has profound effects on their mental health. So, and it happens a lot. So it's frequent and it has a really high risk of serious injury. So what does that tell us about the third element of reasonable practicability, which is controls? Well, it means we must be very quick to put those controls in place, or otherwise we're in a lot of strife at safety law and under every other law. And finally, those controls have to be supported by the resources of the organisation. So if I've got to move someone for them to be safe, then I need to move someone for them to be safe. That's using the resource, not just financial resources, but restructuring how we manage stuff. So can I just say, under safety law, what is a safety system has 6 elements. It is, what is your safety plan? Okay, what is your plan around managing this behaviour? Do you have one? Hope so. All of you employ more than 100 people, so you have to report against it to the federal government. Do you have a plan? And the plan is risk-based. In respect to that plan and identifying the hazards and risks, you're then required to identify what those controls are and set up processes to ensure those controls are in place to prevent it. Now, those controls are mainly based around training and supervision, okay? Then you must train people and prove that that training was competency-based. You must then supervise that, so you must be satisfied that all people who supervise know what the plan is in relation to their area. They know what the processes are, that is, they have a living knowledge of the relevant job descriptions, they know what behaviour, good behaviour looks like, values, code of conduct, they know the policies and procedures, and they know that law applies. That is what they're required to do to supervise, and they must enforce it. Remember, if we let people go and don't enforce it, we're doing something called the doctrine of condonation. We're permitting something, which means when somebody does and we want to stop it, we can't, because you can't punish what you've permitted. So if we have people coming in late, for instance, or we have people making sexualized jokes and we let it go and it's part of the matey culture that you have, then I can't terminate somebody who does it the next day and says something that's sexually inappropriate. I can't discipline them because I've let everybody else do it. What I have to do is start again, draw a line in the sand and say, any of this behaviour occurring again will lead to disciplinary consequences. We haven't done it in the past and we've failed. But do you notice what's happened when I've done that? The person who's injured, there's nothing I can really do with them. I can try and protect them a bit and say, sorry, but I'm not going to get rid of the person because I'm not going to succeed. The person will be reinstated if I try to terminate them. So it is very important we don't condone, okay? Now, when I told you what those 6 is, right, I think I only go up to supervision. There are 2 other elements are monitoring to ensure that it's working, which are things like audits, walkthroughs, discussions with people, and the reporting system against the plan. So 6 elements: plan, process to implement the plan, training that's competency-based, supervision, monitoring, and reporting, okay? How do I know when I have to train? I don't do just annual discrimination and harassment training before Christmas parties. If I've got people I know are misbehaving, I need to train that group now, straight away. Until I'm satisfied they're competent, I've got to know that they're safe and they're behaving in a safe manner. So remember, although we might have annual training stuck in our plan and our budget, if we come across something which is a risk, we have to start training again, because it's critical those people understand that if they do this thing, they will lose their job, they will lose their house. And we're not an organisation that hurts people. We don't let people hurt people. So let's just swing on to the next slide. This is a real test to see if Simon's awake. It's very good. So bullying is what we're going to talk about very briefly. It's dealt with under the Fair Work Act, and the Fair Work Act says you're not allowed to bully. It defines bullying in the way that I have. It doesn't allow the award of damages. It allows the court to make orders, and those orders, can I tell you, are deeply intrusive, because they can tell you how you must configure your workplace to protect the person. Can you imagine running a line where a person who is a boner is not allowed to work next to the other boners but must work as a boner? That's what you're asking. This is a jurisdiction that doesn't care, okay? It doesn't care about what you want as an employer. It wants to provide safety for that employee. So no damages. If you fail to do what you're ordered to do, then you are in contempt and you can be taken to the federal court and fined, and if necessarily imprisoned for failing to do it. You don't want to end up in the bullying jurisdiction, okay? You do not want to be there. Safety, as we know, is much more frightening. So let's use an example, and I know it's an exaggerated example, so please don't get too fired up when I do it, but it's one that's happened recently in which we're dealing with. 2 young men were working in a group of older, very experienced men. They were isolated from the group. In other words, the older group used to go drinking at night and didn't invite them along. The older group used to give them terrible work to do when they didn't want to do it. They were rude to them at times. They treated them like fools. And one of the boys was particularly vulnerable. And as a result of lots and lots of behaviour like that, his vulnerability, he already had suffered from depression in the past, came back. That depression meant that he became incredibly anxious. And when he got home, after being incredibly anxious, he was trying to climb up a ladder to get something out of the attic in his house. And he wasn't concentrating, and he literally missed the ladder, the top step of the ladder, and just fell straight through the floor. It wasn't a deliberate attempt, but his parents who were watching described it in a way which was pretty graphic. Now you'd say, didn't happen in a workplace, so I can't be liable for a general breach because it's not an unsafe place of work, it's not an unsafe system. Okay, good. Okay, so I can't be charged for that. Could I be charged for reckless endangerment, which is 5 years jail, $3 million fines in nearly every jurisdiction, around about $3 million. Let me think that through. Did I do something? Did I or the organisation do something which they knew would have a risk of serious injury or death? Yes, they did. So there's the first element. Were we indifferent to that risk? Well, we're certainly indifferent to the risk of the person developing anxiety and becoming disabled by that anxiety. So yeah, look, we're up there. We've probably got a tick there. Did the person suffer a serious injury or death in the workplace? No, they didn't. They suffered it outside of the workplace. So therefore, they can't be guilty of reckless endangerment. However, in Victoria, Queensland, the ACT and Northern Territory, soon Western Australia and South Australia, you can be guilty of workplace manslaughter, or what's called industrial manslaughter, because to prove that, I've got to show that you owed a duty to the person when they were at work. Okay, well, that's proof. Breach that duty. Okay, pretty easy to prove that. In this case that I'm talking about, the supervisor was aware of the way that the young kids were being treated. He was aware of the impact it was having on one of the young kids, and he'd said it once to the guys, "God, you've got to stop this," but saw them continuing to do it and did nothing more. Clearly a breach of a primary duty to provide a safe workplace, clearly a breach of a safety system, clearly a failure to enforce that system. So very serious general duties breach. The next question is, was he grossly negligent in not stopping what was occurring? Well, let's think about it. He saw the risk that could happen to the person. He saw the impact it was having. He saw the degradation of the person's mental state, and he saw the action that was causing it. So yeah, that's gross negligence. There's absolutely no doubt that's gross negligence. And as a result of that, did it cause the person, and the test of cause is, was it the substantial or dominant cause, serious injury or death? Not in the workplace, just serious injury or death. Now, the answer is, from the description the parents gave, the answer is absolutely yes. He was in tears when he got home, distracted, couldn't concentrate, couldn't sit down, wanted to go and find something in the attic, tried to get up the stairs 2 or 3 times, stood there just shaking his head, and the last time got up and was obviously, and they were training, "No, don't get up, please don't get up," and then he fell. Okay, that is industrial manslaughter. In Victoria, for instance, that's 25 years jail for an officer, not for the actual supervisor. But if an officer knew of that, the officer could go to jail for 25 years. It's big stuff, isn't it? Big stuff. $16 million fine. Uninsurable, might I say. So reckless endangerment and industrial manslaughter can't be insured against. And obviously, if you're locked up in jail, the insurer doesn't go to jail for you. So can I just say the safety breach around all of these things is an incredibly serious breach, and it is the fundamental law that sits behind, which is why I've given you the elements of it. Workers' compensation, if you bully someone, there's no doubt the claim will be accepted. 13% of all claims made in Australia over the last 5 years are stress-related claims relating mainly to misconduct. Around about 45% of all other claims are made have some sort of psychological sequelae, mostly related to the way people were treated. So that's a big portion. For the direct stress-related claims, which is not quite the right expression, for the mental injury claims or psychological injury claims, they represent 25% of total claims costs, which means by the time someone puts in that claim, they will not be coming back. That's a huge premium impact. So what I'm talking to you today about is very simple. If we see someone treating someone badly, whether it's bullying, discrimination, harassment, we see them doing that and we don't intervene. And we probably had 2 or 3 chances, which would have taken us 20 minutes. We don't do that for a large organisation. So for a TIS or for an organisation of that size or a midfield, that's $1 million worth of premium for not doing something for 20 minutes, for not morally caring for someone. That's a huge punishment. Now you work on a 10 to 12% margin. That means you've got to sell $10 to $12 million worth of meat to recover the premium cost. That's a very large expense, okay? All right, so I just want you to understand that's the impact of it. Now the types of bullying range from what I call implied things, which are exclusion, isolating, overworking people, underworking people, to more deliberate types of things like being abusive, shouting, threatening, okay? The defences under the Fair Work Act for bullying are, sorry, I just pressed something on my screen which went very wrong. For bullying are that the person is no longer being bullied, because you can't go and get a stop bullying order if the person is no longer being bullied, which is why the moment you know this happens, you move people so they're not being bullied. The second issue is, the second defence is, it's not bullying as a matter of definition. It might be misconduct, but it's not bullying. And the third one is reasonable management action. That is, was the action that we are taking in respect of this person reasonable in the circumstances, and the way we behave, was it reasonable? Okay, now that's a defence under bullying. It's exactly the same defence under workers' compensation. I've already defined to you, if we can show that what we did everything reasonably practical to prevent bullying occurring, and it did occur, then the organisation will not be liable under safety law. The individual will be liable, and under every statute, individuals who fail to exercise reasonable care, that is a competent person doing their job, to prevent injury to themselves or others, and fail to comply with the lawful and reasonable direction is a crime. Isn't that good? Isn't that great? We can actually use safety legislation and say, no, you're actually committing a crime. No, you're not ignoring our policies. You're doing something which you know causes risk to somebody. It's very serious, okay? All right, now how to manage those risks and problems are very straightforward, aren't they? We require supervisors to stop the behaviour. We require our supervisory management group to know what is wrong and to intervene immediately. And we provide an environment which is safe for people to come forward and say, look, I'm not feeling safe because of A, B, or C. Okay, it's very, very straightforward. And I've put more detail actually in the book for you to talk about how to manage it. Let's go on to the next one, son. So equal opportunity I've explained to you, which is discrimination law. I've told you what a protected attribute, and in the book I've listed every one of them for you. So they go from gender to HIV status to all sorts of things, okay? In Victoria, there are some differences. So in some states, age is an attribute, so treating someone differently because of their age. In Victoria, the way they look is a protected attribute, okay? And that's commonly relates to calling people fat and ugly and things like that, okay? Victoria is the only place that has that. Direct discrimination is me saying to you, because you come from Pakistan, I'm not giving you this job, okay? Protected attribute, race, effect, direct, very, very straightforward. So that's a direct form of discrimination, but it's more often than not indirect. And that's when we create a rule that has the effect of discriminating against somebody. So it might be, we're going to have our early morning meeting on a Friday at 5 a.m. and it would normally be, for the Friday shift, we'd normally be starting at 7 o'clock. I know that's not the case, but I'm just using this as an example. Well, that's very well for all the single men. They can get there at 5 in the morning. But for women who have primary responsibility for bringing up kids, dropping them at school, or dropping them at care, they can't change that. And caring responsibilities, okay, the responsibility of caring for children is a protected attribute. So if I create a rule, we're going to meet at this time, and it's going to have an effect on someone else, I'm discriminating. If I say, look, the meeting's going to be upstairs, so that means all people with bad knees who can't climb stairs can't come to the meeting. Indirect discrimination. Does that make sense? Where I say to people, look, I'm only going to employ strong men on this line because it's hard work. Well, you'd want to know exactly what are the dimensions of that hard work before you started doing it, because it could be indirect discrimination, okay? I've talked to you briefly about harassment and sexual harassment. I'm not going to spend more other than to say to you that the damages claims are going through the roof in it, okay? And therefore, be really careful about it. It is a big issue. I've explained very carefully already in relation to all the law I'm talking to you about. If you can prove that no part of this was the fault of you, that you've acted reasonably, then nearly in every piece of legislation, you are safe. It is the person who did it. Now, when we look at what the defence is for equal opportunity, and this is where we're going to spend a little bit of time, the defences are A, I didn't discriminate and harass. B, it was lawful for me to discriminate. So like Fernwood that runs women's gyms, I've got a certificate from the HHR, which is the equal opportunity, the federal equal opportunity, which authorises you to run a business which does discriminate. And you have churches and all sorts of things which have rights that relate purely to religious beliefs. So there is a capacity to lawfully discriminate. But other than that, there are no defences. Now, the difference is when we look at injuries. If I can show that a person is not fit for the inherent requirements. Now, what are the inherent requirements? The inherent requirements for the job are those substantial parts of a job that need to be done. So if I use the example of Bogues and Button, which is a case where a supervisor at Bogues had to supervise a group of men who were working there. Occasionally, he had to assist in the lifting of 25-kilogram barrels, and he had a right rotator cuff injury, and he couldn't do that. He had to do it 2 or 3 times, once a month or once every week or so, not much. The assessment by the court showed that there was no financial loss as a result of the young boys helping him do it rather than him doing it. But it really wasn't a major part of his job. His major job was supervision. So it's not every part of the job. You know, when we have our executive catch up, the COO goes down to get the coffee. She's the highest paid coffee getter I've ever known. It's not an inherent requirement of a job. So if she can't do that because she's got a sore knee, I can't sack her. So the defense around someone suffering an injury and treating them differently is they're not able to do the inherent requirements of the job with reasonable adjustments. Now, a reasonable adjustment is making some alteration to the business to allow them to do the job. But that reasonable adjustment can't cause unjust hardship. So it can't mean you come off night shift, you never work night shift again, because that means other people have to work it. It's unjust towards other people. It can't mean that I buy a $400,000 machine to assist you to do that job. But it may mean that I put in a step, I put in a ramp. They're all things which are reasonable adjustments. So I'm allowed to treat someone differently in respect of their injury if they're unable to do the inherent requirements of their job with reasonable adjustments. I can say, no, I'm going to terminate your employment. Now, the limits on that, just so you know, under the Fair Work Act is you can't do that unless they've had 3 months off or used up all their sick leave in a rolling 12-month period. If they're putting a workers' comp claim, each jurisdiction, oh, it's 2 don't, but most jurisdictions have what's called an obligation period, which means if they're on workers' comp and they've been off for a period of time or doing light duties in Victoria for 12 months, say in New South Wales for 6, I'm not allowed to terminate them during that period of time unless it's for misconduct, not in respect of the injury, which is compensable. So understand, in the background of this, I want you to be clear, we can terminate people who are injured and unable to attend work, but there are limitations around it. But the analysis I've got to do in every day is if somebody is injured, not a workers' comp, they injure themselves outside of work, I've got to assess, can they do the inherent requirements of the job? No, they can't. Are there adjustments that could be made which don't cause undue hardship? Yes, there are, then I need to do it. But remember, giving someone a different job is not making a reasonable adjustment, okay? You might choose to do that, and if you do choose to do it with one person and then don't do it with another person, you're in real trouble. Okay, let's move on to the next slide, son. Okay, we might move past this, I think, to solving problems. We're up to problem solving, aren't we? I think that's it. I haven't looked at my slides for a little bit, so I think this is what we're actually up to. We have 2 problems here that we've got for you, okay? Let's do this one. There is a second problem as well, which deals with discrimination, but this is the bullying one, and I'd be interested for you to have a think about it. Jane works in a boning room at a meat processing factory. Her role is to pack trays of meat at the end of the line. She also has cleaning responsibility to help the boners. Ray is the supervisor. He's seen Jane performing cleaning tasks, not to the standard which is required and which she was trained at. So let's stop now and analyse. Jane has a job. If we go to the how, why, what, okay, what do we know? We know what her job description is. Her job description is packing and cleaning. And she has been trained, that's remember down the bottom, that is the how, policies and procedures. She's been trained on how to do it, so she knows how to do it correctly. So what does Ray do? Each time he speaks to her kindly. So he's complying with the what part, isn't he? He's complying with the values of the organisation. He's not being rude, he's speaking to her kindly. Tells her, so where am I going? I've lost it here. Reminds her of the process that is required. So he takes her back to what is required under her job description and under the policies and procedures. Each time she says the line speed is so fast she can't keep up with the packing and do the cleaning correctly. Now that would be a legitimate complaint, wouldn't it? If that was true, that's something that Ray has to address. But Ray knows that's not true. We go down a little bit further in here and you realise that Ray is aware that the line speed has been the line speed and it's been faster than this before, and both she and other people have been able to do it at that speed. So it's not true. In fact, her saying it annoys Ray a little bit because Jenny, who did the job before, had no problems keeping up. Now, can I just remind you of my 3 C's? Jane has absolute clarity about what her job is and how she is to do it. She is capable of doing it, and we know what capability looks like. So can you see how the 3 C's play out at this stage? It's pretty clear, isn't it, that this is a commitment issue from Jane. Jane is not committed to doing the right thing in the organisation and trying. All right. The next thing is in the crib room, Jane sits with other members of the team. They all like Ray, and they've known him for many years. He laughs and chats with them when they chat to him. Jane doesn't speak to him, and as a result of that, Ray, who prefers his own company when he's taking a break, doesn't speak to her. So the question Jane's going to raise in this whole issue is, I'm being isolated. You see the bullying parts that's coming in? He's repeatedly speaking to me. I can't do the job, so he's not being reasonable in what he's doing. It's unfair in the manner in which he's performance managing me. It's affecting me adversely. He's isolating me from other people. Therefore, I'm being bullied. What are the 3 elements of bullying that we have here? We have repeated conduct. This is what she's alleging in this one. It's unreasonable in that it hurts, humiliates, or intimidates. She's clearly saying she's feeling hurt from it. And it affects her safety at work. So let's read the last part of the problem. After Jane does not clean properly for the 4th day in a row, Ray asks Jane to come to his office and counsels her around cleaning. She breaks into tears and says he's picking on her. He excludes her socially and she feels bullied. Now we've got some questions to that. I'll just open I don't think they're actually on the slide. They're actually in the book. So bear with me a little bit. I'll be a second and I'd be interested to hear what people say are the answers, and I don't want you to look at the bits of paper I've sent through to you because I won't be happy about that. Does anybody think that Ray is bullying Jane? I'm going to take that silence as a no. You're absolutely right. Ray is not bullying Jane. In fact, he's doing what is called reasonable management action, which is a complete defence to bullying. He is fair in the reason he is talking to her. How do we say he's fair? Why, how, what? He goes to what her job is. He behaves in accordance with the values. He identifies she is not. He identifies the policies and procedures and the expectations of her. So I've done how, what, why, okay? And he's done it in a fair way, okay? So the reason he's done it, it's fair for him to have this conversation and he's doing it in a fair way. That is reasonable management action. So what we know with this problem is there is no doubt at all that Ray is not bullying. The next question is, has Ray committed an act of misconduct using the 3 C's? Why, how, what? Well, we've just said no, he's nailed it, hasn't he? He's got it absolutely right. There's a case that came out a couple of days ago where a Ray type character dealt with a person who'd been significantly bad over a number of years and they eventually terminated. And the court ended up commending the Ray person by saying, no, you did. You looked through the lens of what his job was. You made sure that he was to do his job correctly, that he had to behave in an appropriate manner. You behaved in an appropriate manner. You then went through what the expectations were of policies and procedures. You failed to comply with it. You were fair with him about that. We're going to uphold the termination. So Ray did pretty well. Okay, next question is, Jane leaves the office and doesn't return to work next day and submits a workers' compensation certificate of capacity and claim. The doctor says she is suffering from reactive depression as a result of Ray's conduct towards her. Will her claim be accepted? I know this is not terribly interactive today because I just keep talking, don't I? Well, I'm just going to tell you, if you talk to Simon and you get the right support, the claim will definitely be rejected because you have a defence of reasonable management action. Imagine if Ray hadn't behaved like this and this woman didn't come back. So she's a $60,000 employer, $60,000 a year employee, and she never comes back to work. So let's use New South Wales, Queensland and Victoria at the premium liability on that. And just say you're a business the size of Midfield, which is over $1 billion a year. So your remuneration is in the sort of $100 million category. That is around about $1 million claim in premium in any one of those 3 states. So can you just see maybe 3 or 4 discussions Ray has where he's not kind, he is a bit rude, he doesn't do the right thing, or that there is no proper job description, so there is no fairness as to what's being required, or there's no policy procedure training, or people don't act in accordance with the values. anyway, and so the behaviour of her was not that much different than other people, and the claim would be accepted. All of that is in the control of your supervisors and managers, all of it. And it's about to cost you $1 million, and all I have to do is supervise and manage correctly. I mean, it's just such a great story. It's so easy, isn't it? The training that we're talking about today, if they could just learn this book, they'd be fine, if they would enforce it. Let's go to the next one and see if we can just get through the second problem, Simon. Okay, we've got a couple of extra minutes spare because we started a couple of minutes late. John works at an abattoir on the kill floor. He removes skins from a carcass that moves along the line. He's 54. He has had several shoulder and back injuries over the years and used to work as a boner until he developed problems with his right dominant side rotor cuff. One weekend, he fell off his trail bike and hurt his right shoulder. He went to the hospital emergency department. They put him in a sling and said he had dislocated his right shoulder, and an MRI evidenced a further tear and degeneration of his right rotor cuff. 6 weeks later, his GP said he was safe to return to work with reasonable adjustments. They included no lifting above the shoulder height, no pulling or lifting of weights greater than 10 kilograms with his right arm. The company doctor quite properly said the underlying deterioration in his right shoulder meant there was no surgical improvement in the shoulder that could be made, and his job required him to pull with a pressure of greater than 10 kilograms occasionally. The union said he should be given light duties whilst his shoulder strengthened and then return when he was fit for his old job. Alternatively, they said the requirement to pull a weight greater than 10 kilograms happened rarely, maybe 3 or 4 times a shift, and he could get someone else to help when they wanted. The company doctor said there was no foreseeable time, with or without surgery, he'd be safe to return to his job. Now, what I want you to see here is older employees, and I'm an older employee, our health deteriorates over time. Now, we might get injured even at work, okay? And as we heal from that injury, it doesn't change our underlying health, makes us unfit for the job. So when you're ever doing assessments of people, one of the critical things is to find, after recovery, what is their underlying health. And if their underlying health is not causative, if the injury is no longer causative of what prevents them from working, it is not a compensable injury. Let's be clear about that. But let's look at what the questions were. And I'm just going down my page. Sorry, I have to get to the bottom here. I'll be with you in just a second. Right, the first question is, was the pulling on the skin for a greater pressure of 10 kilograms an inherent requirement of the job? Now, we gave you Bogues and Button's case. This is exactly what this guy's job is. And it's not 3 or 4 times a month, it's every shift he has to pull hard. So it is definitely an inherent requirement of the job. And on our doctor's basis, he will never be fit to do that again. Okay, so the test of whether you can terminate someone's employment once you get past the obligation period is, 1, not fit for the inherent requirements the job is not. There are no reasonable adjustments that can be made. Okay, well, let's talk about, are there reasonable adjustments that could be made? Because that's question 2. Well, the only reasonable adjustment that can be made, because the stripper of the hide does require physical effort to pull it off. It gets stuck and you've got to pull hard on it from time to time. So the only way you can make an adjustment is to get someone else to help you. That is drawing someone else off the line. Have you ever tried telling the owner of the business you're going to stop the line to help somebody pull a hide off? I dare you. You won't get much permission with it. So it is not a reasonable adjustment because it is unjust. It causes loss to the business and continuing loss to the business, okay? The next question is, what about light duties? Why couldn't we give him light duties? If it was a workers' comp claim, up until the end of the obligation period, we are obliged to provide him with light duties. But it's not a workers' compensation claim. It is an injury that arose outside of work. And the obligation is for them to be able to do the inherent requirement of the job with reasonable adjustments, not some other job. Now, it would be a reasonable adjustment to build up someone's strength in their shoulder to require them to do some build-out duties, maybe not that job for 4 to 6 weeks, but not forever. And remember, and this is the really big case, there's a fantastic case that happened in Queensland where a woman who was a nurse was unable to work on night shift because she'd suffered an injury outside of work. And that caused her to have neural issues at night time. She'd been kicked in the head with a horse. She said it was reasonable for her to work day shift. And they ran this 3-week piece of litigation, which probably cost them about $500,000. And they lost the case because it was found that the hospital, on 4 or 5 occasions, had actually permitted people, young nurses, not to have to work night shift and do rotational shifts. They'd allowed them to work day shifts because of relationships that they had with those people. They were family, friends, they were well liked. Whatever it was, they ran this piece of litigation, and through the discovery process, it came out that there'd been 4 or 5 other nurses who had been allowed to do different duties. So I remind you of this because when you look at your place, aren't people treated differently from time to time? Well, that's okay. That's when you'd actually do a skills assessment. You might put someone in charge of quality. Okay, you might have somebody who's got 30 years experience who gets injured, and you say, look, you've got such a great knowledge of the meat industry, you'd be great in quality, we're going to train you up and do it. That would be a reasonable adjustment. Whereas a person who injures themselves who's 40 and doesn't have that level of skill, you mightn't be obliged to do it. But remember, every time you make a job for somebody, I want you to understand, you show that making a job for somebody is a reasonable adjustment. That's a big risk, isn't it? Right, they're the 2 problems I've got. I'd love you to read the workbook. The workbook is designed for you to go out and train people, okay? It's for you as a resource for you, but also to go and say to people, okay, let's sit down and have a 20-minute discussion about discrimination, and let's look at people who have injuries. Let's talk about how we would manage that to a supervisor group. So please utilise, that's how Simon and I designed it to be used. You'll find at the end of the chapter there is 10 questions to ask, which again you can get other people to do. Just cover up the answers, because on the bottom of the 10 questions are the correct answers, okay? I hope you enjoyed that. Is there any questions at all, Amanda?
Thanks, Andrew. There's been one question come through. When with counselling, should there be a third person present?
Depends a little bit on what your enterprise, if you've got an enterprise agreement. So there's a lot of bad language used. There's things like informal warnings and counselling, and they're wrapped up, and at times they're really a warning. So if what you're doing is warning somebody, you should most definitely have a person present with you, okay? The law is that unless you're about to terminate someone, you shouldn't deprive them of a support person. But have a look at your enterprise agreements if you've got enterprise agreements, because there will be a right of representation there for the union to be present. Okay, so slightly different thing. But answering your question, Amanda, if I know I'm dealing with a complex employee, so I know, and we all know who this employee is, it's likely to end up in a psychological claim. And you can see this coming. I'm not talking about the everyday person who's got injured. This is the person you know is trouble, okay? Well then, no matter what I was doing, I'd have somebody present, because I need to prove that I've been acting with reasonable management action. So it's more strategic rather than required. So the law, the Fair Work Act says, I cannot unreasonably deprive a person of having a support person present when I go to terminate their employment. The courts have looked at that, and it probably drops down to when you're giving a warning. It's wise to have a support person. Remember, unless the enterprise agreement says representative, it is a support person, and a support person is only there to provide emotional support for the person. They're not there as an advocate. Okay, be very clear. If they are as a representative, they have representational rights, well, they can come along as an advocate, and you need to be very clear to separate out the discussion around the evidence versus the representational advocacy part. How does that go, Amanda? Does that make sense?
Great, thanks so much for that. Excellent. Well, thank you, Andrew. That's the only question that you've had come through, so you've done exceptionally well. So just like to take this opportunity to thank you for taking time out of your busy schedule today to present to us and give us some really good insights into the workplace bullying, and also for the work that you've done in developing the workbook that's been emailed out to everyone. I do also have a second email that I'll be sending out this afternoon, which has the answers to some of those questions in that workbook. And also thanks to Simon and the Aegis team for their work in the background in helping with developing the workbook. This series has been developed from the recommendations of the AMPC project, Making the Red Meat Industry a Safer Place, which was conducted by AMIC in around 2018, and from the feedback from the previous webinars. So thank you for coming on board, Andrew. Just also wanted to put a plug in for the workplace risk advisory line that we've currently got going. It's a trial that also came out as a recommendation from that project, and it's going to be running for sort of the next, or it's going to run for a 12-month period. So you can call the hotline on 1300 761 891, and you'll be directed to one of the Aegis dedicated team that will triage the call and direct the inquiries to the relevant specialist. So this is something that's open for all AMPC members, and for any safety, workers' compensation and insurance claim matters, Aegis will direct you to the most appropriate person within their organisation. And for the HR, IR related issues, these will be directed through to AMIC. So please use that service. It is free to AMPC members, and we encourage you to make sure that you're getting all the support that we can possibly offer you. We'll also send out a reminder and some examples over the next couple of days around that hotline and how the advisory section works. Just in closing, just want to let people know that the next webinar schedule is on aggregated waste to energy, and that's going to be presented by All Energy on the 17th of September. And then part 6 of the WHS series, Bullying and Harassment and Safety, which will be presented by Jay and Simon from Aegis, will be on the 24th of September at 2 p.m. So we look forward to having everyone attend that. So once again, a big thank you to Andrew and Simon for today, and best wishes and stay safe. Thanks, everyone.
Thanks very much, Amanda. Thanks, Simon, and thanks, Tam. Cheers.